Good morning. It's Thursday, October 2nd, 11:18 in the morning. I'm out of the whole Cook County Jail. I want to thank Judge Donnelly and Judge Cecil for sending me here, and I still love you guys and the 3 state's attorneys, even though they have to cheat and lie. I still love you guys. I'm not mad at you guys. You guys opened up my eyes to what's going on in the jails. I have a lot of stories for you guys, very interesting stories. A lot to do with judges, murder, extortion, all kinds of good things. I appreciate what you guys did for me. I love you guys, and I hope I set you guys in the right course, because when I was in court, when you guys took me out of jail at the Daily Center 19 months ago, now I'm going to have to show you guys what the Sun-Times Mr. Abner Palish didn't tell the whole area of Chicago. It'll be in my internet. And thank you. And I'll have more to say. This is a bullpen. A lot of room. Plenty of room. Plenty of room, Mr. Dart. This is a bullpen. Yeah, like I said, Dart, this is the bullpen. They have more room than the Cook County Jail. It's Jaime Hernandez. I'm here this morning making a little tape here to show how Russ Stewart, the lawyer that I couldn't fire because of Judge Donnelly, said he was doing such a good job, even though we had 1 mistrial. The judge said, no, he's doing a good job, you can't fire him. And even though that my lawyer was trying to sue me during trial, which was illegal for him, still the judge said, I can't fire him because he's doing such a good job. I have all kinds of stuff here. We have a notice of emergency motion. This was for, while court was going, Mr. Stewart seen this, and he was looking at, he was being very nosy. What is that, Jamie? I said, this is, don't worry about it. I filed a motion this morning. He had made me sign additional appearance to go pro se while I had a lawyer, which is illegal. This additional appearance was filed August 22nd, 2008. Stewart, outside the courtroom, he, oh, come on, Jamie, sign this, sign this, sign. I didn't know what it was. I was too afraid to sign because I was, it was a stressful time for me. So I signed it, and some buddies of mine seen it and all that, and they said, whoa, that's wrong. That's not wrong. That's wrong what he did. It says Jamie pro se. I certified that a copy of this has been filed by the courts. So I did a notice of emergency motion. And Mr. Stewart seen this, so we had a sidebar in the back of the judge's, some little room there. It was telling the judge that what Mr. Stewart made me sign was illegal, and the judge, tried to blow me off. Okay, we took care of it. But in here it says, Jaime Hernandez, defendant in want of effective counsel, moved this court for an order finding the attorney-client agreement that his defense attorney, in this case, induced him to sign on or about August 22nd, 2008, to be illegal and unenforceable. He also moves his court to sanction the defense attorney for violating this court's order as well as the law, and shows as follows. This court may not be inclined to hear or rule on these motions because they might imply the court's endorsement of hybrid representation, but defendant submits that consideration should not apply to these motions because a defendant has a constitutionality protected right to document the ineffective assistance of his counsel, if only for eventual appeal purposes. And B, these motions denounce his defense attorney's successful attempt to induce him into hybrid representation in violation of this court's very order on that subject. On or about August 22nd, 2008, this court denied defendant's attorney motion for leave to withdraw from representing defendant in this case over the objections of both defendant and his attorney. The only reason that the defendant knows that could justify such a denial is if the case were already in trial. But this court did not disclose its reasoning why it considered this case to still be in trial when its first jury had already been dismissed and a new jury had not been yet selected. Defendant would appreciate learning by what appellate or Supreme Court authority the court supports its position on this matter. Number 4. In any event, within minutes after this court's denial on August 22, 2008 of the above said motion, while still in the courtroom and they continued in conversation as they walked together down to the clerk's office together, defendant attorney induced defendant to sign an agreement making him defendant co-counsel with him, defendant defense attorney, for the purpose of the upcoming trial with a newly selected jury. See Exhibit A. In light of this court's first order in the case of August 26, 2008, which dealt with the illegality of hybrid or simultaneous representation by counsel and a pro se litigant, and in light of plenty of other case law to the same effect, defendant agrees that such an attorney-client agreement was and is illegal, hence unenforceable. Defendant contends that in so illegally inducing him, his defense attorney violated this court's order on August 26, 2008 that was issued just minutes prior to the illegal inducement. He also thereby violated considerable case law on this subject, and he also thereby violated Illinois Supreme Court Rule of Professional Conduct 3-1, 3-3A, 6, 7, and 12, as well as probably 5-5. The defendant has a U.S. Constitution protected interest in document. Well, enough with this talking. The judge seen this. He didn't do a damn thing. He just ignored it, and the court went straight ahead. And then I seen some other stuff here. I don't know where I got this. Defendant's motion in limine. I don't know how I got this. And here it is. There's A, B, C, D, E, F. Where my lawyer did all this stuff without me knowing. Well, he admitted the audio tape and the transcripts, but he never brought that in. And he borrowed for an order borrowing state reference to Sheila Mannix, a litigant in case number 06-0P-30185. The nature of her case, her background, her civil, criminal history, and her relationship, if any, to defendant Jaime Hernandez. That reference to Sheila Mannix will be prejudicial to defendant. Lie. I had nothing to do with her. That's the first time I met her in her courtroom. And C, for an order barring any state reference to the reason why Jaime was in courtroom 1506 on February 2nd, 2007, as such information will be prejudicial to the defendant. I don't see how it could be prejudicial. Anybody can go to a courtroom. That's granted. Number D, for an order limiting state witnesses to those disclosed in the answer to discovery filed on September 20th, 2007, to wit, Deputy Sheriff Morrissey, Ola Jowers, Reynolds, and Gaydon. Granted. We had a whole mess of more witnesses. We had Abden Palish from the Chicago Sun-Times, but he didn't show up, and my lawyer said, we're going to go on with the trial. Even my wife couldn't testify, and even Russ Stewart. I even heard that Linda Aker and Eugene Zorek, that they didn't have to show up. That you didn't need them as witnesses. Well, if they showed up for witnesses, I would have won. But that's the way it goes, because I already knew. I told everybody, Russ Stewart. I told everybody, the court is forcing you to screw me, but they're going to take care of you. They're going to pay you back. I don't know how they're going to pay you back, but they're going to give you something in return for screwing me around. But that's okay. That's the way it goes. E, to bar any photos taken by defendant, cell phone, and confiscated by deputies on February 2nd, 2007, or said evidence was not tendered to defendant in discovery. Well, those photos of my cell phone, there are no photos. The judge knew that. The state's attorneys knew that they were not going to allow the jury to know that. This is how the judge and the state's attorneys hide evidence from the jury. They intentionally hide it. They intentionally hide it. I knew I didn't take no pictures of, supposedly, like the state's attorney said, taking pictures of security. Like I was some kind of terrorist. I'm not a terrorist. State's attorneys, judges, you guys are the terrorists here, not me. Because there are no photos. There never was. And it's sad. And even though if I did take pictures,